employment law, how to draft a successful appeal. Hi, welcome to our channel. Today, we're going to break down the key steps you need to know to draft a compelling appeal, whether it's for a legal case, employment issue, or other formal dispute. Trust me, getting this right can make or break your case. So, stick around as we dive into the essential components of an effective appeal that will maximize your chances for success. But first, did you know that timing and legal precedent are everything? Let's get into it. Smash the like button for the YouTube algorithm. Be sure to slow the video speed settings if you want to watch the video in a slower pace or take notes. Drafting your appeal. Facts, legal precedent, and timing. To draft an appeal that historically prevails in court requires a well-reasoned argument, clear legal principles, and supporting case law. Here we will clarify the general structure of a strong appellate brief for an employment law case involving, for example, discriminatory retaliation and constructive discharge based on being replaced in the position you were hired, being separated from work and placed into remote status work, and eventually resigning due to the working conditions. Adjustments may be needed depending on the specific facts of your case, relevant legal doctrines in your jurisdiction, and the appellate court's requirements. Smash the like button for the YouTube algorithm. When drafting your appeal, the facts are the foundation. Make sure your personal facts are clearly presented and tied to legal standards and case law. This is the key to showing the reviewing body that your case is grounded in reality and the law. Don't just list the facts, connect them directly to the relevant laws and precedents. Next, you'll want to use strong legal precedent. Case law is critical to backing up your claims, especially those that align with your jurisdiction. For example, if you're working on a retaliation claim, look at cases like Pennsylvania State Police v. Sutters, 2004, or Kakmer v. SunGard Data Systems Incorporated. These cases can guide how to frame the issues. If your position was changed to the point where you could no longer perform your duties, resulting in a forced resignation, Sutters can be particularly helpful. Here, the court found that employers either deliberately created or negligently allowed such conditions, emphasizing timing in retaliation claims. Now, let's talk about temporal proximity. This is especially important in retaliation claims. Simply put, this means showing how close in time your protected activity, like filing a complaint, was to the adverse action within your appeal, like a demotion or termination. The closer these events are, the stronger your claim for retaliation. Structuring your appeal. Smash the like button for the YouTube algorithm. So, how do you actually structure this appeal? Here's a simple framework. Introductory paragraph. Briefly explain why you're appealing and what outcome you seek. Statement of facts. Lay out the key facts of your case in a clear and concise manner. Standard of review. Explain the legal standard that applies to your case. Arguments. This is the meat of your appeal. Apply the facts to the law and case precedents like Sutters or Kakmer. Conclusion. Sum up your arguments and reiterate the relief you're seeking. And don't forget a verification statement at the end. Your verification statement should look something like this. I, your full name, hereby affirm that all the statements made in this appeal are true and correct to the best of my knowledge. I understand that any false information or misrepresentation may result in the dismissal or other action. Then, of course, you sign, date, and provide your contact information. Legal precedent. Using cases like Sutters. For example, if you're appealing a constructive discharge claim dismissal, Sutters is an important case to reference. The court found that when an employer either knowingly or negligently creates conditions so intolerable that an employee is forced to resign, that can constitute a constructive discharge. Tie this precedent to the specific facts of your case to strengthen your appeal. Remember, your appeal needs to be grounded in facts, law, and with correlations to timing. It's not just about telling your story, it's about showing how the facts, timing, and legal precedent all work in your favor. If you follow this framework, you'll be setting yourself up for the best possible outcome. Thanks for watching. If you found this video helpful, don't forget to like and subscribe for more tips. Disclaimer, we are not a licensed attorney. Instead, we offer words of wisdom from our life experiences which we hope to help you become informed when you are going through difficult employment actions so you can be set up for success and not suffer as we did. Legal processes are complex, and the little guy is often taken advantage of. Let's inform the little guy so they can have a more fair process. Knowledge is power. When you do not have knowledge, good luck getting fair outcomes. Comment below, do you find this video helpful? What do you want us to create videos on? Do you have any questions on all we discussed? Do you agree with our write-up for how to file an appeal? If you have any questions, drop them in the comments below. See you next time. Smash the like button for the YouTube algorithm. Click on the on-screen images to subscribe and watch more videos. See playlists. We organize all our videos into playlists.